many meetings did you have with Mr. Clark?
One, that I can recall.
And then what was your decision?
I heard, well, ultimately I decided that I was going to proceed on two paths. I was going to consider a plea agreement to certain terms that I was amenable to, and at the same time I was going to pursue, ask for additional trial counsel.
Additional trial counsel from who?
From DOJ.
Okay. What point in time again is this? Is this early 2023?
This is in March of 23. I had a meeting in D.C.
Okay.
I had subsequent meetings with my team. I had lost one of the two. Mr. Morgan had left the team by that point in time, so I lose one critical member. And I've been advised from one of my own that she is preparing for it.
That's Ms. Wolf.
Yes. So now I've got two members of the team. And my view was, look, I am prepared to proceed with plea discussions on these terms. I had a clear understanding in my own mind, except for one point, what those terms were.
What were those terms?
Those terms were the two misdemeanor charges, the failure to pay charges, and diversion on the gun, ultimately. It didn't happen in day one, but that's what I had sort of had in my mind by March 23. The only thing that was hanging was what recommendation I would or would not be willing to commit to at that point in time. So there were, didn't know that plea offer was going to, we were going to reach an agreement on that, I should say. And given what I heard today, there would have been no reason for me to believe there was going to be an agreement between the parties on those terms. So at the same time, I wanted to put together a team that would be prepared to try the case moving forward, whether it was on misdemeanors or felony charges.
Okay.
And what I had decided was the misdemeanors, because Ms. Wolf raised this, we have the misdemeanors, never really had much concern about my proof on the misdemeanors with respect to 17 and 18, particularly failure to pay. So I was willing to proceed. I thought, given a lot of thought, I was willing to proceed on those misdemeanors, but I wanted folks in the case that were prepared to try the case if that offer wasn't accepted. And I wanted to hear from the new trial team as to this trial team's assessment of felony charges for 18. Okay. Because if the new team agreed that they weren't well-founded, then it would have been misdemeanors.
And where did you get the new team from? Who did you request that?
Requested it from ODAC.
Via Mr. Weinsheimer?
Yes.
And how did that process work? Did he just give you lawyers, or did you have an opportunity to select from a pool of lawyers?
I made the request, and Mr. Weinsheimer was amenable. I don't know exactly what they did in that regard. I do recall at some point talking with Director Wilkinson, because I happened to run into him at an event, National Security Division seminar type event, and I knew that Mr. Wilkinson had spoken to Mr. Weinsheimer, either through Mr. Weinsheimer, probably through Mr. Weinsheimer. So I bumped into Mr. Wilkinson. I remember asking how we were doing in that regard. And didn't have a whole lot of success.
What do you mean you didn't have success?
In finding...
they didn't give you lawyers?
I got one resume.
Okay. Nobody wanted to come prosecute Hunter Biden?
I don't know that, I truly don't know the details of what transpired. I just don't.
Okay.
I wasn't part of those discussions, but as events are moving, we ultimately had a meeting in D.C. with Mr. Clark and Mr. Weinsheimer's participation. And I remember that was in later April, and I remember following up with Mr. Clark, with Mr. Weinsheimer at that time, talking further about it. And actually, as I think about the sequencing, I had started to reach out myself directly to offices or people that I knew and make my own inquiries.
Okay, so ODAG wasn't being especially helpful on this front in identifying individuals for it.
I don't want to say that because I don't know that they weren't trying to find people. All I know was I didn't get a whole lot of resumes.
Eventually you get Mr. Wise and Mr. Hines as the prosecution lawyers.
That's correct.
When did you get those two fellows?
I got Mr. Wise in the latter portion of May.
Okay, and Mr. Hines as well?
I got Mr. Hines through Mr. Wise. Both of them had been AUSAs in Maryland, and probably a couple weeks, 2-3 weeks thereafter, I think.
And did you find them, or did Mr. Weinstein or somebody in ODAG find them?
I found Mr. Wise with the assistance of somebody at the public, at Public Integrity.
Okay. So after they joined the team, at some point, did you have a discussion again about bringing the case in California?
Well, I would have shared the process memo on the tax charges, and my first question, I would have asked whether this was first, is this something you'd be interested in? And I'm sure early on, and remember, so I know you're familiar with the sequencing of when I filed the diversion agreement and plea agreement sometime around June. I'm having these discussions with Mr. Wise and Mr. Hines at the same time. So these events are literally moving on parallel tracks. And so I'm sorry. What was the question again?
Well, I was just, asking about the decision not to bring the case in California after you had a gap where you needed assistance of prosecutors. And that gap was how many months?
A couple months. I started in early March, and we had limited success through the end of April.
So DOJ said you had the authority to bring this case, but when it came time to get prosecutors to actually bring the case, you met a real roadblock there, didn't you?
As I said a moment ago, I did not receive a lot of resumes in response to my initial request.
Okay. Did Mr. Weinsheimer explain to you why that there was such a drought there?
No.
Did he explain to you what efforts he undertook?
I don't recall us ever talking about it.
He said ultimately somebody from the public integrity section helped you identify Mr. Wise. Is that correct?
That's correct.
And was that pursuant to your outreach? Or did the
Probably.
public integrity official?
No, probably.
Much discussion last time you visited with us about the fact that you asserted that you had ultimate authority over the matter from the very beginning. Can you walk us through sort of the evolution of how your authority came to be characterized as ultimate authority?
I think the only significance to ultimate is that word was used in response to the chairman's letter, I think dated June 7th, but so I don't want to attach undue significance, although I understand why it draws attention, but my view is I had the authority to make the decisions during the course of the investigation and the charging decisions with respect to Hunter Biden. I said so then, I continue to maintain that today.
But with tax cases, the tax division always has to approve tax charges, and with a noteworthy defendant, certain levels of senior leadership of the department have to sign off on indictments and so forth.
That is accurate. And I remember us discussing that quite a bit the last time. And yes, as I agreed previously, there are approval requirements as part of the Criminal Justice Manual, and tax division approval with respect to Title 26 expenses is very much part of that.
So if the tax division didn't approve filing the charges, you would not have the ultimate authority to proceed with it, correct?
That's correct. If the tax division chose to say that, to take the position that a charge I was recommending move forward under my discretion, and they disagreed, they could have said no, and as we discussed last time, could have then taken that to either the Office of the Deputy Attorney General or the AG in order to resolve whatever impasse that was currently before.
I want to draw your attention to the second, the below email. There's two emails here. This is from Jack Morgan to Leslie Wolf, submitting 9 exhibits relating to potential Mann Act violations. And we know from your indictment that Mr. Biden was using the Owasco Corporation to pay for women to fly different places. Correct.
Well,
Right, he was taking a business, he was using, he was essentially personal expenses.
He deducted a flight as a business expense, and the women, that was a girlfriend at the time that she was a witness on our behalf. But I wouldn't consider that flight a Mann Act violation. At least, it's not something I'm ever going to consider customary. And I haven't seen this, I don't think I'm on this, and no, I never seriously considered, nor do I recall anybody ever presenting, or not only not prosecution, but for consideration for prosecution, the idea of a Mann Act.
So when Mr. Morgan sent these 9 exhibits through, this was the end of it, Ms. Wolf?
I don't remember the beginning of it, so I wasn't on this, I don't think. There are some redactions. I assume I'm somebody who would have been redacted. But I don't recall us ever investing significant time at all into potential Mann Act violations. I do remember that Mr. Biden had relationships with a number of different women at different times. And that may have entailed certain travel, but we were focused on attacks, particularly early, it was primarily attacks yesterday.
But those expenses that he paid, he ultimately took his deductions as from the Owasco Corporation, correct?
I remember the one you mentioned. I remember one of the many expenses that we took issue with and claimed were truly personal because of business and therefore not deductible. At least one, if not more, involved flying someone from the East Coast to LA.
And you asked for the removal of Mr. Shackey and Mr. Ziegler, is that correct?
No, I did not ask for the removal. I asked for a new team. I asked for a new team, I believe, in late April, or sometime in April or May of 23.
So you asked for a new team, but you're saying you didn't ask for the removal?
No, I asked.
You know how many parsing words here?
I understand why you asked the question, but I specifically asked for a new team. I've done that in the past, and I don't think in this circumstance, but I communicated that request to agencies as U.S. Attorney under various circumstances. It's not a given. I've been refused that request more than once in the past.
When you asked for a new team, who did you ask?
I asked the special agent in charge at that time of that tax group.
Okay. And what was the feedback you received from the special agent in charge? Was that Mr. Walton?
No, Mr. Walton had left. It was, I believe, Kareem Carter.
Okay.
And I think I communicated the request verbally, and I think I got something back saying that they would talk about it and we're working on it. And ultimately,
they replaced Mr. Shackey and Mr. Ziegler?
they assigned a new team, yes, and Mr. Shackey and Mr. Ziegler assisted with the transition, but were no longer participating in the case moving forward.
Why are you interested in having them removed?
Again, I understand the characterization. I'm saying I asked for a new team. At that time, and we discussed some of the circumstances that occurred in the spring of 2023, I was contemplating, as I communicated, moving forward the case. And Because I was contemplating moving forward with the case, I had asked for a new attorney team. I wanted a new team from the Internal Revenue Service. And yeah, there were circumstances that prompted that. Yes.
For the tax years 2014 and 2015, that encompass Mr. Biden's Burisma income, is that correct?
Yeah, I don't want to touch on 24 and 2015 unless we can resolve this, because it's my understanding that, as I said in the report, for me to discuss 24 and 2015 would necessarily, even if I acknowledged it, it touches on return information and the fact that the authorities were conducting an investigation of the taxpayer on that return. And my understanding of the case law and the application of 6103 is that's a problem.
Okay. I mean, one of the big reasons we had you here is to answer questions about why you didn't charge 2014, 2015. When you testified the first time, you said you're going to put that in a report. You didn't put that in the report. And so this is, one of the core interests of Congress is to find out why all this Burisma money. I mean, Hunter Biden's making $1 million a year, and he's not paying tax on it. And then when the authorities put together a tax case, and according to Mr. Shapley and Mr. Ziegler, they had a very strong case. The case was just poof. It goes nowhere. So
I understand, I really do. And particularly on this issue, if I wasn't concerned about 6103, I'd be more than happy to discuss this issue. When I said that I intended to discuss this issue when we met last time, that was absolutely my intention. I am much more versed in 6103 now than I was at that time. In fact, I really wasn't, unfortunately, I really wasn't focused on that particular issue at the time. I've become more conversant in it now, more than I want to be. And I am concerned. Now, if somebody tells me that the department has authorized me to speak to it, I'd be happy to do it, but it hasn't happened. I'd say generally, with respect to a tax investigation, not that there's anything special about it, you're looking at various years. To the extent I can put together, and this is general, a case that involves more years than not, and allows me to more fully develop allegations about a course of conduct and a scheme, that's better for the prosecution. So it's not like I'm looking to cut out years generally when you're pursuing a tax investigation.
Well, that sort of begs the question, and why do it? That was sort of the most obvious thing with millions of dollars and the political aspects of Burisma. That's the fundamental question. And now you're telling us 6103 prevents you from telling us why you made a prosecution decision or decision not to prosecute on the most glaring example.
I understand, absolutely, yes. And I wish that I could have done it, but it's my understanding that for me to trip into 2014 and 15 is a violation of 6103.
according to, well, let me ask you this. Shapley and Ziegler testified that the prosecution team was looking at pursuing charges for 2014 through 2019.
I see the exhibit number 1 you provided. I see that those years are on there. And so I acknowledge that that's what exhibit number 1, if it's somewhere, says. But other than that, I am reluctant to say anything further about it because of 61.
We were discussing the authority provided by DOJ to the witness. And specifically, the committee has interest in asking questions about why the 2014 and 2015 tax years were punted, in effect, by the Department of Justice. I mean, Hunter Biden earned well over $1 million in those years, certainly $1 million from, millions of dollars from Burisma, and that he didn't pay tax on it, and that has gone completely uncaptured. And it's fair for a Congressional Oversight Committee to ask questions about the circumstances of that. And you have been provided a letter from the Justice Department authorizing testimony on this topic, and council has said that you're concerned about potential prosecution, and certainly prosecution by this Justice Department would be fruitless because there's a letter from them authorizing it. Now, if you're concerned about prosecution by a subsequent Justice Department, if the Democrat administration comes in, I mean, that would be really something. If the Democrat administration comes in and wants to prosecute you for talking about the Burisma years. So that actually is at the crux of, that's just a pretty outstanding statement.
I do not see that carved out within 6103, nor has the department cited authority for it to me. You indicated that I'm concerned about potential criminal prosecution on behalf of my client. That is true. As I've laid out, administration's changed. The statute of limitations for prosecution for this type of violation is 5 years. That's longer than any administration stands. While I agree with you about the perhaps unlikelihood, we don't deal in likelihood or unlikelihood. We deal in competent legal representation. The other thing we're concerned about is potential civil liability if Mr. Weiss were to disclose without proper authorization taxpayer information. An aggrieved taxpayer could seek to bring some type of civil suit against him. For those reasons, we've requested, but not been granted, immunization and indemnification from the Department of Justice.
Can you help us understand, why your report was so short?
My report, I looked at the regs closely. I understand what prior special counsel had done in terms of reporting. We had secured convictions for the tax return case, an extensive record based on all the pretrial litigation that had been undertaken in those cases, as well as the prosecutions of Mr. Smirnoff. And so I was mindful of that, and there was an extensive record created by virtue of our prosecutions that were part of the public record. And I also had closely looked at the regs and what my charge was in terms of fulfilling my responsibilities, which was to explain my charging decisions, and that's what I tried to do. When the pardon was announced in December, it certainly was part of that calculus and deciding, okay, what's appropriate under these circumstances.
Okay. When you were with us in November of 2023, a lot of our questions, you indicated to us that you would be addressing in your report.
I did. I recall that.
And so,
and I intended to at that time. I would not have in any way misled the committee. I intended to fulfill that, what I said that day.
But circumstances changed. Is that because of the pardon?
Well, that was part of it. That certainly was part of it, because from my perspective, the pardon that covered 11 years of Hunter Biden's conduct, those matters had been disposed of. I thought it was inappropriate for me to comment further on that because they were taken off the table. Then the question was, even if those matters had been investigated, third parties were involved. And I was uncomfortable with the notion, consistent, I think, with department policy, with Hunter Biden being on the table and his conduct, discussing what any of those investigations had meant for third parties, that I wasn't going to charge.